Today, the U.S. Supreme Court decided to hear the mifepristone case and to grant certiorari, which means take review of certain questions that were asked in the case. This case actually started a couple of years ago, but really caught fire in April 2023 when a district court judge essentially declared that mifepristone's approval by FDA should be invalidated. That decision was then reviewed by the U.S. Court of Appeals for the Fifth Circuit. They didn't go all the way with the district court judge, but they did say that essentially we need to restrict access to mifepristone and put us back to a regime that was in place before 2016. Now the U.S. Supreme Court will review only the question about whether that latter piece, changing the access regime to the pre-2016 status, was appropriate or not. And that's the question the Supreme Court has agreed to hear. But the most important predicate question is whether the plaintiffs in this case have standing. So these are the main things that are on the table. Up to what week can you use this drug? Does a physician have to be the one to administer it? How many visits? And whether those visits have to be in person. Those are some of the things that are on the table in this decision. So it's always hard to read the tea leaves, but I think it's probably good news for the federal government and for Danco, the company, and for women who want access to mifepristone across the United States. So what that means is that the Supreme Court is not interested in completely making mifepristone unavailable, that is completely undoing the FDA approval. At the very worst, we will be returned to the regime that was in place in 2016, which was a more restricted approach. But I think that the more general signal is that the Supreme Court, I think, is being very skeptical of the opinions in this case and is likely to be particularly interested in standing, which is the question about whether the challengers in this case, the plaintiffs who brought the case, even have the right to be in court to begin with. This is a drug that is incredibly safe. And we want to kind of make it clear that it's being held to a very different standard than many other drugs, including Tylenol or Viagra as comparisons, right? And we shouldn't kind of kid ourselves to think that this is just the neutral application of a usual FDA process and the review of an FDA process by the courts. This is an aggressive anti-abortion push. And it's really quite an exceptional thing when the district court essentially announced that a drug that had been approved by the FDA after a very searching and careful review, one that had received a lot of scrutiny from Congress, had to be taken off the market. I think it's just really important to kind of focus on how exceptional what's going on in this case is and how motivated it is by antipathy towards abortion and abortion access in this country.
I think the political implications are mammoth. And I think that all through this, ever since they decided against Roe v. Wade, people have underestimated just how important this is to most Americans, especially to American women. And what we've seen now is we've had several referendums and several elections where the issue clearly was abortion, and the pro-choice side won and the right to lifers lost. And this will keep happening. And it'll especially keep happening as the horror stories build up of what this has done to women and women's health. And of course, I'm referring to the woman in Texas who has had to leave the state. She has a terrible medical situation. I'm a mother of 3, a grandmother of 10. So I know plenty about this topic. I never heard of trisomy 18, but this is awful. She wants more children. This could ruin her chances of having more children. And 9 men in Texas decided that no, she couldn't have an abortion when she's carrying essentially a dead baby inside her. This is outrageous. This is just so outrageous that the public is going to keep paying attention to this, and they're going to keep punishing the political party and the politicians who are going along this path.
I do think in this particular case regarding mifepristone, where it's complicated questions about an agency, FDA, its rules, and the way it weighs evidence, I do think the Supreme Court will find attractive a way out of dealing with much of that. And I do think this question of standing presents itself as a way out where they don't have to engage quite so much in weighing the evidence that was before FDA and how FDA did it and how much FDA discretion is allowed, that they can simply decide this question on its face and decide the plaintiffs don't have standing. I will mention one other thing, which is to say, Judge Ho, who wrote a concurring opinion, a very aggressive concurring opinion in the Fifth Circuit, also flagged the question about whether an old act from 1873, the Comstock Act, which is a federal statute that bans the use of mail and common carriers to transport obscene items or items intended for producing abortion, actually is involved in this case because mifepristone often goes through the mails. The Supreme Court did not indicate that it's interested in taking up that question in this case, but there are a number of other cases that I think will eventually make its way to the Supreme Court, and that's going to be a very important question to keep one's eye on.
Pretty easy toast to have it. I can take your offer for you.
It has helped the Democratic Party in every single race where it's been an issue, and where it's been a clear-cut choice on a referendum, it has won overwhelmingly. So this will almost certainly help Biden, and part of the way it helps him is it will energize young people to turn out and vote. And young people, they don't always vote. They're not always, enthusiastic about it. This is going to really mobilize young people. And this is going to help Biden, and it's going to help Democrats all the way down the ticket.